We're in the final stretch at the Employer Summit here this afternoon, excuse me. The day's stretching on here. I began early for me. So we got two sessions. We have our WCG Employment Ontario session, and that's an interactive. So you'll be hearing from Amanda Baresi from WCG Employment Ontario, but we're actually going to conduct the discussions at the tables. So this is a table talk type approach. And we'll end off the Employer Summit with the great people from Eamon Harnden to do an employment law update, something that was extremely popular and highly rated last year. So again, we're coming up to our WCG Employment Ontario Table Talk session. To introduce that session, however, it's my distinct pleasure to welcome an organization that is very, very well known to all of us. Everyone knows of CAA, right? You've heard this brand CAA. And when you think of CAA, you probably think of maybe they're the people I call when I get a flat tire in my vehicle, or maybe when I can't get my car started in the winter. But that's the old version of CAA. CAA is grown in such remarkable ways and just recently launched, very pertinent to this crowd of people, CAA Business, which includes lots of perks for employers. So without further ado, please welcome the head of CAA in North and Eastern Ontario. Here is Jeff Walker.
Thanks, Michael. Thanks so much. Appreciate the opportunity to be here. I'm going to talk for just a couple minutes before we bring Amanda on. I'm Jeff Walker, and yeah, I'm the CEO of CAA North and East Ontario. Everybody, as Michael alluded to, everybody knows the CAA, that they probably used it one time or another in their life. We actually have 390,000 members. We're in 1 in 3 households. So we're a pretty significant organization in terms of being connected to people as consumers. And what we made a decision about a few years ago was that we wanted to keep expanding what it is that we do and the various businesses we're in. And one of the things we did, for example, we started this thing called a pit crew, where we show up in your driveway and we change your tires and we change your oil so you don't have to sit around at the repair shop for a day or two waiting for these guys to decide if they're going to do your tires. And that's just one example of the kind of thing we do. We decided that a new thing that we could do was to bring some of the value and some of the trust that CAA offers to consumers to businesses. And so we are now offering this product called CAA Business, and it has 4 business lines. We are in our roadside assistance business, which everybody knows what that's for. Imagine you're a small fleet, you got 10 trucks, you don't have anybody to take care of those trucks. If something bad happens, we're here for you. We're here for commercial insurance, so you have your business insurance, you get a letter in the mail, and oh, they've just decided to raise your price by 20% for no reason. Go online, check out the price. I think you'll find out it's a pretty good deal. We're also in the group benefits space. So we are now, for those of you in the HR space, offering a group benefits offering that's a really great value prop. The short version is small and medium-sized company benefits that are analogous to what large companies can get. So we're leveling the playing field for small and medium business, and we encourage you to look into that. And then finally, that same pit crew thing that we're doing for consumers, we're now doing it for small businesses. So you have your trucks on Industrial Avenue somewhere in a park, and that day in spring or fall where you need those tires changed and that oil changed, we just send our crew out and do the whole thing all in one day at your facility. So those are the core offerings we have under CAA Business, and we are very excited to launch it this month. We've got a whole bunch of cool benefits that we're making available through all kinds of partners like the Ottawa Senators, Bell Media, and others that are all available to those companies that sign up for CAA Business. That's enough of that. Let's get on with the next session. I want to introduce Amanda Baresi. She is the Senior Employment Services Manager of WCG, and she's going to guide you guys through a focused table talk exercise to understand your recruitment needs and explain more about how publicly funded employment services can connect businesses to local talent. Amanda?
Hello, everyone. As mentioned, my name is Amanda Barassi, and WCG Services leads the 22 organizations with 30 locations across Ottawa and the surrounding area in the delivery of employment services through funding from the provincial government. This is WCG Services' third year as presenting sponsor for the Best Places to Work, Career and Training Expo and Employer Summit. While we celebrate the best places to work, we're very intent on connecting people to those best places to work. So just a little bit of background, no-cost services supporting job seekers and businesses are by no means new, but the model is enhanced and offers more supports and resources to employers than ever before. Our providers work with small and medium-sized employers like yourselves and HR leaders from large businesses who want close connections with referral partners like Employment Ontario and to serve as an extension of your recruitment efforts. So think about above and beyond the job posting. It's really about connection and relationships. And as we've heard today, it always is. So as I mentioned earlier, the 30 Employment Ontario locations serve approximately 25,000 job seekers annually. The diversity of job seekers is wide-ranging, similar to the sectors represented as best places to work. We work with entry-level candidates all the way up to highly skilled professionals seeking their next career move. And amongst the room today, we have many of our different Employment Ontario representatives sitting at the tables with you to be able to guide those discussions with you today. So what I want to do is, this is the key, what you see on the screen here are the logos, the representation of all of the providers that you may know of in the community. Or if you don't, take note because these are all our providers across the area that are working with job seekers and who can serve businesses like your own to connect you to talent. The key takeaway message after we go through this exercise that I want to leave everyone today is that Employment Ontario is committed to helping businesses connect with job seekers. It's that simple. So while this might be the beginning of a partnership for some of us, or as a reminder that there is a network of providers at your service, alongside you at the tables are representatives, and we're going to go through a little rapid fire survey. We should be able to see a couple of questions up on your phone, and up on the screen. But until those pop up, we want you to provide your responses on what 6 topics could make your recruitment easier for your business. So one would be support with the recruitment process, and that might mean something like a local pipeline of job-ready candidates, stronger links with colleges or universities, support with job description or advert templates, interview structures, pre-screening, tools and advice on using platforms, or simply a place to post jobs that local candidates could access. The second prompt, is everybody seeing it on their phones? Oh my gosh, okay, this is great. So I'll just read through. Oh, there it is, look at that. Pre-employment training and work readiness. So some of the things to think about there are individuals who have improved their soft skills communication. We've heard a lot about that today. Work trials or job placements, support with shortlisting or screening candidates, and recruitment support during busy periods. Another option would be to look at candidate engagement and expectations. So what does that mean? Well, support with helping candidates stay engaged throughout the recruitment process, and also support with managing candidate expectations. So when our Employment Ontario providers are working with job seekers, they're supporting those candidates along the way. So any of those unknowns or areas of confusion that somebody might have, that's what that person has in their corner. Another option would be funding and incentives. So there are wage incentives for hiring new staff, help in accessing apprenticeship or internship funding through partners, and support to bring career returners back into work. So I'm glad that there's two more, sorry, but I'm starting to see some of the answers come in. And it's looking like there is definitely a appetite for support in some of these areas. Data and labor market insights is another consideration. So as a business, are you looking for local data on candidate availability, maybe salary and benefits benchmarking? And the last but not least, partnership and ongoing retention support. So really a single point of contact for recruitment and workforce support, regular check-ins and longer-term partnerships, and better coordination. If we go to the next question, there we go. Just a quick poll on which of the following would enhance your recruitment immediately. So if you had a magic ball and you could say, tomorrow if I had some help with this, would that be supportive? An ability to promote vacancies right away, pre-screening support or referrals of candidates, or possibly to host an in-person hiring event. So we're gathering this data because these are the types of supports that we have come to learn through our existing employer relationships and working groups and industry partners. And these are the areas that Employment Ontario can support your business. So there is an opportunity to connect with us today in person, but there's also an opportunity if you wish to leave your contact information. If you scan this QR code, you can leave your name and contact info, and somebody will get in touch with you immediately. I think the whole purpose of having our network come together during an event like this is to recognize that there are so many of these organizations that are found in and amongst your neighborhoods, and we're all working towards the same goal. For those of you who are not yet connected to Employment Ontario, you can always fill out your information, like I mentioned, or you can chat with your Table Talk representative. Most of us will be here for the rest of the day, and we also have a booth on the Career Expo side, and we just look forward to connecting with you. Thank you.
We're into, as I said, the final stretch, and we're ending on a great, very practical topic that all of us need to be aligned with on a day-to-day, hour-by-hour basis, employment law. And we've got a terrific presenter. She's back by popular demand from last year. Let me read this next session description. Employment law is constantly evolving in this post-pandemic environment. The session will explore the trends and changes in workplace law. Understanding these changes is crucial for maintaining compliance, mitigating legal risks, and fostering a positive work environment. Get informed and ensure your practices align with the latest regulations to protect your business and employees. The session is sponsored by Eamon Harden LLP, a great boutique employment law firm situated right here in Ottawa. Please welcome Samira Blitsky. Here she is.
So I have the pleasure of once again being the last presenter of the day and speaking to you about updates in employment law. The purpose of the presentation today is really just to go through a few different topics and provide you with updates on various subjects that will be important moving forward from an HR perspective. So we're going to be covering three main topics. The first is updates to the Employment Standards Act, which most of you know there's been a lot of them lately. Then we'll move to human rights updates, so updates with respect to different human rights issues in the workplace. And then finally, we'll deal with termination clauses, everyone's favorite topic. So, okay, perfect. So Employment Standards Act, last year when I was here, we talked about a bunch of different updates. I'm just gonna move this out of the way. And a lot of those have been implemented, but they haven't all been implemented. And so we're going to go through a few of the ones that have come into force over the last few months, some as recent as last week, and then another important one that will be coming in January. So the first one is long-term illness leave. And like many leaves under the Employment Standards Act, this new leave requires that an employee have at least 13 weeks of consecutive service in order to be eligible. And this is specifically for employees who will not be able to perform the duties of their role because of a serious medical condition. Now, you may be asking yourselves, okay, what's a serious medical condition? Unfortunately, the Act is not defining that, and so it's been left to the discretion of what they're calling a qualified health practitioner. Under the Act, luckily they have defined that for us, and a qualified health practitioner is a physician, a registered nurse, or a psychologist. As of right now, those are the three categories of health practitioners that are accepted for this type of leave. Importantly, it requires a medical certificate from that specific practitioner that outlines that because of a serious medical condition, the employee is unable to carry out the duties of their job. The leave itself can be up to 27 weeks in a 52-week period, and the employee doesn't have to take all of it in one shot. So for example, if an employee is dealing with a medical condition where they need to be off for maybe a few weeks at a time, they can do that. They can have a few weeks on, a few weeks off, as long as it doesn't go beyond 27 weeks in a 52-week period. And so this leave came into force in June of this year, so it is a current leave that is available to employees. The next change, and this is one that a lot of people will be familiar with, is the obligation to provide employees with various information when you're an employer with 25 employees or more. And so this information that you see listed on the slide has to be provided before the start date. I find, given that this change came into force on July 1st of this year, the most convenient way to do this is through an employment agreement. And a lot of the employment agreement templates will already have provisions related to a lot of these items. And so it's very easy to add a sentence here or there to make sure that you're complying with the ESA and you're providing the information that's described. The other ways that you could do this are through a letter of offer, a short kind of one-pager. You could send it by email. As long as you provide this information prior to the start date and in writing, you've complied with the ESA. The next important update to be aware of is the increase to minimum wage. So as of October 1st, for provincially regulated employers in Ontario, minimum wage has been increased to $17.60. There are other minimum wage increases to other types of categories of jobs, as you'll see on the screen: students, hunting, fishing, wilderness guides, and home workers. It's also important to note that these are just the general rates for those types of categories of jobs. And in certain instances, there are exceptions. So if, let's say, a student is working less than a certain amount of hours, the minimum hourly wage will actually be lower. So it's really important to consult the ESA because there are various exceptions to these items. And the other thing I wanted to note is we're really focused on Ottawa and Ontario today, but the Canada Labour Code also recently increased minimum wage for federally regulated employers. So for any federally regulated employers, employers in the aviation industry, banking, telecom, the hourly minimum wage has gone up to $17.75. So provincial and federal are close to being on par at this point. And then in terms of another change to be aware of that is on the rise, that is coming, we finally have a date for the job posting changes. So, hopefully everyone's okay. So we talked about this last year when I was here, and I will say this is something that we get questions about all of the time in terms of job postings, right? This is something that people are very concerned about, making sure that the job postings include all of the information that the ESA prescribes. And so as of January 1st of next year, you will have to start to implement the changes that we've been talking about. It feels like for 2 years now. And so any publicly advertised job postings from an employer with over 25 employees will have to include the expected compensation or compensation range. Now, there are exceptions to this, and notably one exception is if you know that the compensation for the role will be $200,000 or more in terms of the salary, you don't actually have to include that in the job posting. The other thing that has to be included is a disclosure of any use of AI in either the selection process, the interview process. If it's used to screen the applications or assess applicants, that has to be disclosed in the job posting. And then finally, you do have to also disclose whether the job that you're posting for is an existing vacancy or if it's a new role within the organization. We're going to talk about this a little more later on, but the other addition to these changes relating to job postings is you can't include a specific requirement for Canadian experience. And this is something that was always an issue with respect to a human rights liability or violation, but now the Employment Standards Act specifically is outlining this as a prohibition that you cannot include that and you cannot base your decision on Canadian experience. And then the final change that's kind of related to job postings or job competitions is the employer now has an obligation to provide any applicant or job candidate that you interview with an update about whether a hiring decision has been made. And that has to be done within 45 days of the last interview that the candidate underwent. With respect to maintaining information, there now is an obligation to maintain any information and documentation obtained or collected in the job competition for 3 years. And then last but not least, in terms of additional changes on the horizon, there is a new unpaid leave that is going to come into force in the future. We don't have a date for it yet, but it's something to keep in mind. There is a placement of a child leave that's going to come into place. And this is a leave that is kind of the government's answer to parental leave when there's no pregnancy involved. And so this is a situation where there may be a child coming into a family by surrogacy, adoption, what have you. And so any employee that's dealing with that situation will have a leave of up to 16 weeks for that specific purpose. Just like parental leave, they have to give written notice of when they want to take that leave, and it has to be provided at least 2 weeks prior to the date upon which they want to start. So very similar to what we're dealing with in terms of parental leave, in terms of the timelines. But again, this hasn't come into force yet. It will be coming into force in the near future. Okay, moving on to human rights. So in terms of human rights, something that we're seeing a lot of still is COVID-related issues. And so the two cases that I'm going to talk about are with respect to kind of return to work issues or mandates post-COVID. What's important to note is that the cases I'm going to talk about are cases that were rendered in 2025, but unfortunately because the Human Rights Tribunal of Ontario is quite backlogged, it takes several years for a matter to proceed through the steps to a hearing. So when we're talking about these COVID issues, these aren't necessarily issues that happened this year. They're issues that happened, in 2021, 2022, but they've only been rendered, decisions have only been rendered now. I'll also mention that as an employment lawyer, these are issues that we still continue to see. It's not necessarily a mandate of, okay, everyone was working remotely, and so now instead of 100% remote, you're back to the office, 1 or 2 days a week. What we're seeing now is employers where they did that a couple years ago, and now it's an increase to the in-office days. So rather than 2 days a week, some employers are changing it to 3 or 4 days a week. And so these issues do continue to come up, which is why we've decided to talk about it today, to give you some information about these issues. So I'll get right into the first case. So the first case is Can and Kneff Properties. In this case, as I mentioned before, this was from a few years ago, and so it was a return to the office, but it was an increase from 1 day a week to 2 days a week. And in this case, the employee requested an accommodation for childcare reasons, and so it would be connected to the Human Rights Code protected ground of family status. And so for childcare obligation reasons, this employee said she cannot come to the office 2 days a week, she can only do 1 day a week, and she requested accommodation. One of the things that she requested was a 9-week unpaid leave. Unfortunately, it was during the summer, so the employer said, we can't accommodate that. Our business needs are just too high right now. But what we will do is, on a temporary basis, we'll allow you to continue working from home 4 days a week while we figure out what this can look like moving forward. Let's figure out what our options are. And the employer asked the employee to come in and meet with them and communicate with them and cooperate with them so they could figure out options. They also offered to help with finding other options for childcare and provide supportive resources for the employee. Ultimately, the employee refused to communicate with the employer over this issue. She refused to meet with them. She refused to collaborate. And she ultimately refused their help and insisted on the one accommodation that she wanted, which was working from home 4 days a week on a permanent basis. And so eventually, the employee resigned, and she filed a complaint, an application with the Human Rights Tribunal alleging discrimination. Long story short, the application was dismissed. And the reason it was dismissed is because the tribunal found that the employer did accommodate the employee. And so the big takeaway from this case, and this is something that the tribunal really focused on in their decision, is there needs to be lines of communication. The employee does have to be accommodated, and the employer does have a duty to accommodate, but it doesn't have to be perfect. It only needs to be reasonable. And there was an emphasis in this decision on there being a requirement for communication. And so because the employee ultimately refused to cooperate, refused to talk to the employer, refused to work through options and discuss this with them, and the employer did accommodate her on a temporary basis by allowing her to continue to work 4 days a week while they dealt with this issue before she resigned, ultimately the tribunal found that there was no discrimination here. The employer did accommodate her and did satisfy its duty to accommodate under the code. And so this decision is a very good example of situations where you do want to accommodate your employees. Under the law, you have an obligation to do that. But again, it doesn't have to be perfect. It does have to be reasonable. And it doesn't necessarily have to be what the employee is asking for. Sometimes as employers, we can do that and we can accommodate and do what the employee would like, but it doesn't always have to be that way. And as long as you're complying with your duty to accommodate, as long as you're accommodating in a way that complies with the law, that's sufficient for human rights purposes. The next case is Bastas and North City Insurance Brokers. And so again, we're talking about COVID. I know, me included in this room, I don't want to talk about COVID anymore. We've had enough of it. But I do think it's important because we keep coming into these issues. And so in terms of this case, there was an employee survey that went out to all staff asking about feedback in terms of the employer implementing a return to the office. So everyone was working 100% remotely. The employer was starting to think about, okay, how do we get everyone back to work? So they send out a survey. One of the employees in that survey gave feedback, followed by a medical note from the doctor saying that for medical reasons, they cannot work from the office. They have to stay working 100% remotely. And that was accommodated for the time being. Very shortly thereafter, about a month later, the employer actually went through a restructuring. And for that employee, the role that they were in, the employer decided to only keep one out of the 2 employees who were in the same role. And so they did an analysis between the 2, and based on seniority and performance and other reasons, they decided to retain the other person in that role rather than that specific employee, the applicant in this case. And so after the termination, the applicant brought a human rights application alleging that they were let go because of their medical condition. And so in going through this hearing, the employee had to prove that one of the reasons, doesn't have to be the main reason, but at least some of the reasoning behind the decision to terminate their employment was based on his medical condition, on his disability. And so in the hearing, the employee was able to actually show 2 out of the 3 criteria that would have to be proved to show discrimination. The first is identifying with a code-protected ground. He had a medical condition, there was no issue there. The second is proving adverse treatment. He was able to show that, that's the termination. The third item is what he wasn't able to show, which is the nexus between the code-protected ground and the alleged adverse treatment. And so there wasn't an ability on the applicant's part to show that it was because of the medical condition or disability that that person was selected for termination. And not only that, but on the employer side of things, they were actually able to show evidence because they had papered the file very well to show that it was actually an assessment based on performance and seniority, and it had nothing to do with the employee's disability. So ultimately, the application was dismissed. And this is a good reminder in terms of accommodation for work-related medical conditions having to come back to the office after COVID, but it's also a good reminder of how if you're an employer and you're dealing with these issues, it's really important to document everything. If you're assessing during a restructuring, whether you keep one employee over another, and that employee or any of those employees potentially identify with a code-protected ground, you're going to really want to put your evaluation in writing to make sure it's very clear, why did you select this person for layoff versus somebody else? And that type of documentation can be very helpful in dealing with these types of disputes. Another case, this is not COVID related. This is just a case that I wanted to bring to everyone's attention because it deals with having signed a full and final release. And we often get questions about what happens if somebody signs a release and then after they say they didn't mean to sign it or they weren't in their right mind. And so this deals with exactly that. An employee was let go, they signed a release. After the fact, he had buyer's remorse essentially and claimed that because he had a disability, the release was null and void and he couldn't have understood what he was signing because of his medical condition. Now, in cases like this, the applicant actually has to show medical evidence of their state of mind at the time that they sign the release in order to have the tribunal or the court, depending on the situation, assess whether they really were able to fully understand what it was that they were signing. In this case, the employee, the applicant, wasn't able to show that medical evidence. There was no evidence that the employee was not able to understand what he signed at the time, and so the tribunal upheld the release, and it was found to protect the employer from any future complaints or claims. The takeaway from this, of course, is to document well, but I also wanted to mention that I do get this question a lot when employees will kind of get a termination package and write back and say, can I have an extension for the deadline to accept this package? I need to consult with a lawyer, or whatever the reason, but usually it's to consult with a lawyer. In those situations, it's really important to make sure that you're not pressuring the employee to sign the release, because any indication that you're pressuring the employee, that you're not giving them the time they need, can be interpreted as duress, and then that can actually lead to a release being unenforceable. So I recommend that if ever you or an employer you're working with is dealing with that situation, check in with an employment lawyer, because these situations can be very tricky to deal with, and they're usually going to be assessed on a case-by-case basis. So you want to make sure that you're getting the proper legal advice from an employment lawyer to make sure that if you're going through the trouble of getting a release drafted, offering a package, offering this release to sign, you want it to be worth the paper that it's drafted on. And then the last consideration for human rights is citizenship. And this is something that, again, I've been getting a lot of questions about in the last year or so in terms of what can we ask employees, what can we ask job candidates in the job competition and the selection process. And so it's important to note that under the Human Rights Code, there are various grounds of discrimination that are prohibited in terms of employment and hiring. And so we have things like ethnic origin, place of origin, and citizenship. So right off the bat, you aren't able to inquire about these things during the job competition process. And for most people, that's pretty straightforward, and nobody would ever ask somebody about their nationality or their ethnic origin or where they're from during their job interview. Generally, we understand that that's not something that you can make a hiring decision on the basis of, because that's a violation of the Human Rights Code. But when it comes to citizenship, that's where there's been a little bit of confusion and a little bit of lack of clarity in the past. And so a couple years ago, the Court of Appeal provided some clarity on that issue. Having said that, it was a couple years ago. I still get questions about this issue all of the time. And in this case, just a quick summary, there was an applicant for a job. He was essentially offered the job, but on the basis that the employer understood that he was able to work in Canada on a permanent basis. And in the job competition process or the selection process, the question was related to permanent eligibility. And so the employer, in this case, Imperial Oil, they actually distinguished between whether someone's eligible to work in Canada on a temporary basis or on a full-time kind of permanent basis. And that's where the problem was in terms of that distinction. And so the employer in that case, once they found out that the employee that they had offered a job to was actually not eligible on a permanent basis because they were on a work permit, they rescinded the job offer. That employee filed a human rights application claiming discrimination on the basis of citizenship. And this went through a couple of appeals up to the Court of Appeal, where it was confirmed that no, you cannot discriminate on this basis. You cannot distinguish under the ground of citizenship. You can't distinguish between somebody's status. So they're either eligible to work in Canada or they're not. You can't go any further than that. You can't ask about whether they're on a work permit, whether they're a permanent resident, whether they're a citizen. Those are the questions that are the no-nos, so to speak, in terms of the job competition and selection process. And so moving forward, the takeaway from this case is just that. You can ask if they're eligible to work in Canada, that's no problem, and that's something that we often will recommend that you ask to make sure that there's no issues there, because as an employer, if you hire someone who's not eligible to work in Canada, there could be negative consequences to the employer, not just the individual that you're hiring. So you want to ask that question, it's important, but you can't go beyond that. You want to avoid asking about, as I mentioned before, permanent resident status, work permit. Those are the issues and the questions that will lead to trouble from a human rights perspective. So that's what you want to stay away from, aside from some very narrow exceptions that are on the screen. And so those are the exceptions. Most of the time, the exceptions do not apply. And so you'll want to stay away from those issues in terms of the job competition questions. Okay, last but not least, termination clauses. We get a lot of questions about termination clauses, and this is something that I'm sure everyone in the room can agree is a frustrating kind of point of contention in the last, I'd say, 5 years, because the law seems to keep changing, right? We keep getting decisions coming out of the court where you thought your clause was enforceable, you got it updated by your employment lawyer, and then 2 years later, there's a case that came out of the court, and all of a sudden, it might not be enforceable anymore. So the hope is in the next kind of few slides to provide some clarity on those issues, because it is possible to draft an enforceable termination clause. And there are cases right now that are kind of up in the air that are really important to be aware of in terms of updating your contracts and making sure that as an employer or as someone working with employers, there's as much protection as possible when it comes to termination clauses and enforceability. So I'm going to talk about Dufault, and a lot of people in this room might be familiar with this case already. It came out in early 2024, and Dufault is the first case where an employer, a judge endorsed a novel argument, and that novel argument was that if a termination clause says the employer has the right to terminate an employee at any time or in its sole discretion, that runs afoul of the ESA, because an employer can't really do that. There are parameters to when you can terminate somebody. It's not quite at any time. It's not quite in the employer's sole discretion. And so because of that, there's a potential violation of the Employment Standards Act, which means that the termination clause would be unenforceable and the entire provision would therefore be null and void. And so that's what happened in Dufault. And Dufault then started this whole concern about the anytime argument. Sole discretion as well, but mostly we hear about anytime. What's important to note is in the Dufault case, there were other reasons why the termination clause was unenforceable. It wasn't just because of this anytime issue, but that was one of the issues that the judge had indicated as being a reason for it to be unenforceable. And so that then got appealed to the Court of Appeal. And the Court of Appeal, this is very important, it upheld the lower court's decision and said, yes, the termination clause is not enforceable, but it declined to comment on the anytime argument. And it specifically, the court said, we're not commenting on this, we're not dealing with this, because there's 3 other reasons why this termination clause is not enforceable, and so we don't really need to get into anytime. This clause is no good no matter what. And so following that, in the employment and kind of HR termination clause field, we were all left kind of scratching our heads with, okay, does any time make it enforceable or unenforceable? We don't know. So in 2025, we've gone through a couple more cases that have commented on this issue. So the Baker case is one that came out in February of this year, where the termination clause, and I've put it on the screen just so you can see what it looks like, the termination clause, again, has that anytime language. And prior to Dufault and prior to last year, a lot of termination clauses had that language because it hadn't been struck down, it hadn't been attacked, it just wasn't really an issue until the Dufault decision. And so this termination clause in Baker has the anytime argument, and it has the anytime language. And so in this case, the employee made the argument again. It says anytime. The employer is not allowed to terminate me at any time, and so it's unenforceable. Similar to the Dufault case, in this case, if you look at the termination for cause language, it also had another issue with the clause, which is that it conflated the threshold of just cause at common law with the threshold under the Employment Standards Act. And so, as many of you would know, under the Employment Standards Act, in order to terminate somebody without any notice, any termination pay, nothing, they have to have engaged in willful misconduct, disobedience, or willful misconduct, or willful neglect of duty. That is not trivial and hasn't been condoned by the employer, right? Those are the magic words, that's the threshold. If an employee meets that threshold, if their conduct meets that threshold, you can terminate without any pay, any notice, et cetera. But if the employee's misconduct doesn't meet that threshold, they may meet the threshold at common law, which is a lower threshold for just cause at common law. And if you're in just cause at common law territory, that employee is still owed their statutory entitlements under the ESA. And so any termination clause that conflates that says, we can let you go and give you nothing for something that would be akin to cause at common law, well, because that's not quite correct and that employee would still be owed their statutory entitlements, the clause is no good because it potentially violates the ESA. And so that's what you have here in Baker, because it says just cause includes, and I'm paraphrasing, but poor performance, dishonesty, and then any conduct that would constitute cause under the common law. So right away we know that that's no good, and that has been no good since 2020 when the Court of Appeal issued the decision in Waxdale. I won't get into that decision, and we have limited time, but I did want to just mention that this case, the judge found that the termination clause is unenforceable for the reason I just mentioned, but also for the anytime language. So we now have Dufault and Baker that both say if a termination clause references a termination at any time, it's unenforceable. A few months later, the court heard another case in Lee and Wayfair. And again, I've put the termination clause on the screen for you so that you can see very similar language. Again, it speaks to any time, termination for any time. This one also talks about termination at any time and for any reason. In this case, this termination clause, aside from this any time argument, was very well drafted and was enforceable. And so in this case, the judge said, I'm not following Dufault, I'm not following Baker, this termination clause is enforceable. It doesn't matter if it says any time. I'm not going to impute an unlawful intention on the part of the employer and say that they were trying to get out of the ESA. I think this clause is good. And so we now have those two cases that say any time is no good. We have this case, Lee, that says it's okay that it says any time. It's still enforceable because there were no other arguments of unenforceability for this clause. There was only the anytime argument. And so it was upheld, and the court decided not to follow those previous decisions. And so where we are today is in terms of this anytime argument, and I lump in any reason with it as well because it's basically the same argument. And we recently did have a case where the court specifically deliberated on the issue of any reason. The clause had a provision that said the employer can let you go at any reason, for any reason, and the court said that that was unenforceable. So we have now one case that says that the terminology of termination for any reason renders the entire termination provision unenforceable. Where does this leave us right now? Well, the Baker and the Lee decisions that I just went through with you are being appealed to the Court of Appeal. The Court of Appeal, as much as they didn't want to deal with this issue in the Defoe case, they now are going to have to deal with it because we have conflicting case law on this issue. And they're going to be hearing the appeal for both cases in the same day in January. So we will have clarity on this issue soon, hopefully not too soon, not too long after the hearing in January. But what do you do for the time being? For the time being, you should be making sure that any termination clause does not have this language in it. Not because it's necessarily unenforceable, because we do have mixed case law, but just to protect any employers against opening the door to that argument, to any issues of unenforceability. It's just not worth leaving the door open on these issues. And so I'd recommend making sure that you speak with an employment lawyer and you have those termination clauses updated if you haven't already, so that that type of language is not there. It doesn't really serve a purpose, it doesn't need to be there, and it could end up being detrimental later on. And then the last thing I'll end on is a good news story, is an enforceable termination clause. So I just wanted to make sure that we're not all discouraged about termination clauses, because you can draft an enforceable termination clause, it can be done, and they can be upheld by the courts. It does happen. And this case in Birch is a perfect example of that. It's a well-drafted termination clause that the court upheld. I'll put it on the screen. I certainly don't recommend copying this. I still recommend going to an employment lawyer. But it is a good example of what will be found to be enforceable, or at least what was found to be enforceable. I can't speak to what the judges will do in the future, unfortunately. But this case did uphold this clause. And importantly, this clause, what it doesn't have is, it doesn't have the anytime, any reason language, which remains to be seen whether that's something that will be a problem moving forward. But it also very clearly limits entitlements to the Employment Standards Act. It doesn't provide the employer with any rights that are outside of the ESA, and it very clearly limits and makes it clear to the employee that this is what they're getting if they're being let go. So I wanted to end on that because, again, it can be a little discouraging in this realm. But all of that to say that when it comes to termination clauses, they can be drafted in a way that makes them enforceable. We don't have to lose hope that you can draft an enforceable termination clause and that every clause is going to be struck down by the court. But we do have to exercise extreme caution when drafting these clauses. And that's all I have for you today. Thank you.
Samara. Thanks again. Thank you, Samara from Eamon Harnden. It's a reminder, I think, Samara, that you do need to stay in touch. The changes just from what you presented last year to the changes and potentially some clarification around termination clauses. I caught that. That might be like an employment lawyer joke. Let's end on some good news: enforceable termination clauses. Jot that one down. And no taking pictures of that enforceable termination clause. Please phone your employment lawyer. I have a great time talking to the great people at Eamon Harnden on some podcasts, so you can check that out on OBJ's YouTube page. All right, the end of the Employer Summit is here. I truly hope you're walking away with a list of to-dos and ideas to create best places to work for the sake of your employees, for your organizations, and even the local economy. As we wrap up, I want to give some last-minute thank yous. First to our sponsors and exhibitors: WCG Employment Ontario, Meldrum Horn and Associates, Eamon Harnden LLP, Ottawa Education Group, Craft Execs, Mindstride, University of Ottawa, CAA Ennoble, and International Business University. Please give them a warm round of applause and show them our appreciation for making today happen. And a quick thank you to our presenters, Alistair, Karen, Amanda, and Samara. Another round of applause for them. Okay. So your full conference pass is a full conference pass, which means we are ending the Employer Summit, but we're moving to Disrupt HR. So you are fully eligible to stay, participate in a cocktail that begins in 1 minute's time. We've got some drinks, we've got some food out there. We have a whole new group of people, about 200 people coming in for Disrupt HR. So we'll really be mixing the crowd and lots more opportunities for networking. I'm sure you might be familiar with Disrupt HR, if you aren't, that is to say, Disrupt HR is a high energy, fast-paced event with 8 speakers who share bold, disruptive ideas about workplace talent, culture, technology, 5-minute talks, 20 slides that advance every 15 seconds. So it's effectively the HR of TEDx, or think of TEDx. This is TEDx in an HR capacity. It's run, by the way, by local volunteer group of HR professionals. So this is a different group running the event in conjunction with us, all very seasoned HR executives. The people that will be speaking here on stage had to apply. They were screened, and they've been training for weeks to give their 5-minute talk.
We've been sold a lie that creativity is a talent for the lucky few. But neuroscience suggests otherwise. Creativity is not necessarily a gift, it's biology. And, better yet, it's hackable. When I work with teams to solve problems, I like to first ask if people perceive themselves as creative. I usually get one of 2 responses. 1, the hands shoot up, or 2, the eyes begin to roll. And in truth, it's a bit of a trick question, because the question should not be, are you creative? The question should be, how do we set ourselves up to be more creative?
Have you ever felt like you were so convinced that you were right about someone's behavior, only to find out that you weren't? Let me take you back to one of the most high-stakes projects of my life. That project was everything to me. It was my chance to prove myself, to advance in my career. Failure was not an option for me. And that's why I gave the most critical task to one of my friends who was with us in the team, and I trusted her. And I was clear, I needed this by Monday. Yet Monday came, nothing. I talked to her. She agreed. 2 days later, still nothing. Then I saw her sitting around with colleagues, laughing as if nothing was at stake here. My mind exploded. She's so irresponsible. How could she do this to me?
So a funny thing happened to me the other day. I asked my wife if she would help me practice this Disrupt HR talk, and she said, sure, but did you use ChatGPT? And she had every right to ask that, honestly, because I thought about it. And that's really the problem with AI right now. We're not using AI to help us grow. We're using it to skip the work. So what does a healthy relationship with AI look like then? Well, I didn't know that my journey to answer that question started about 2 years ago when I enrolled in a mentorship program for people like me. And I was so excited to find out that I had been paired with, get this, the Chief Learning Officer at Starbucks, Mr. Brandon Carson. How cool is that? But that experience got me thinking a couple things. Brandon's bandwidth wasn't infinite. At the end of the day, only I and a few others would be able to benefit from that amazing experience. And when Brandon left Starbucks last year, he took all of that knowledge with him, leaving future generations there at a loss. And so companies, we scramble with this knowledge retention problem, don't we? We build succession planning programs, we invest in leadership development, and mentorship has never been so hot.
AI is loud, headlines everywhere. But the thing is, HR is not late to the game. HR is built for this. The way we work, decide, collaborate, that's not fluff. That's how we get beyond the hype. Here, I mean Gen AI, tools like ChatGPT, built for prompting, built for thinking, helping you shape, simplify, sharpen, spark what's next. After all, prompting is thinking. How can HR help create the conditions, the capability, and the experiments that enable AI to thrive in organizations?
The biggest threat to any business is not its competition, market dynamics, or even AI. It's the unseen tensions that pull us out of rhythm with each other. You see, teams either move together or they move against each other. That's what determines whether they win or whether they lose. Now, you've felt the strain of being out of rhythm before. It's the endless arguments that just keep looping. It's the secret meetings that happen after the meeting. It's the team members that quietly check out. It feels like a barrage of issues that you have to deal with. But really, it's the same tensions that keep breaking through the surface.
Raise your hand if you've ever nodded in a meeting and thought something completely different. Yeah, we've all played the corporate bobblehead routine. We go into meetings where people nod and then walk out with their own agenda. You might be thinking, why am I here, or what's for lunch? Nodding isn't alignment. It's acting. It's corporate improv. Fake alignment's actually rather deadly. Without clarity, projects, products, services, strategy all fail before they even begin. It's like 10 people designing a bathroom with 3 toilets, no door, and a sink in the hallway. Totally useless, but technically sound. And it happens in organizations all the time. It's not theory. There's a global giant that tried to align its divisions around one new system without actually agreeing on terminology or processes. The result? Order chaos, supply chain breakdowns, and $160 million in losses. If you want to burn cash, keep nodding.
You're reading the land acknowledgement at the beginning of the meeting. I close my eyes, feet on the ground, ready to connect. You pronounce the names of the land, of the people. You pause. And then just like that, nothing changes. Pressure returns. Agenda item number 1, power stays exactly where it was. So what are we really acknowledging?
How many of you have heard this before? When pigs fly. It's the way we dismiss ideas that are too bold or too creative. We all know what it means. No way, never, impossible. But what if the ideas we dismiss are the very ones our organizations need most? And what if I told you HR is strategically positioned to make pigs fly? And that unlocking creativity is the key from moving from impossible to possible. The problem, right now, many organizations are stuck. Messy systems, stalled progress, and it shows up as apathy, stagnation, turnover, burnout. And reality is, policies and metrics won't save us. Dashboards and checklists measure activity, not possibility.